Welcome to the last hearing session of this examination, which is about planning obligations and planning conditions. I'll dispense with my formal introductions and housekeeping on the basis that everyone must know the form by now. I do want to repeat what I said at the pre-examination meeting, that the fact that we're having a hearing session on planning obligations and conditions does not mean that I've made up my mind. The Council is obliged by the appeal regulations to submit a set of conditions or heads of terms for a planning obligation in the event that the appeal is allowed, and this is normal practice. I completely understand that any discussion we have this morning will be on a without prejudice basis. You'll know how I run my hearings by now. This is probably a session where I'll be very keen to hear from the Council and the appellant. If the I have no problem with the Community Council contributing, but please make your intentions clear if you wish to make some comments. But normally I'll just hear what the two sides have to say. Before I let you all go home after the hearing session, we'll have a quick wash-up just to check whether there's any outstanding matters and the timetable for closing submissions. I am aware that the appellant and council have been discussing conditions throughout this week, and that's great. Can I start with Mr. Finley? Is there any updates that I need to be aware of?
Well, yes, there have been extensive discussions, and matters have moved forward, and that whilst there are still issues of dispute between the parties, there are, I think there's significantly greater areas of agreement than there had been previously.
That's encouraging. What I was obviously I've prepared the agenda and my own preparation on the basis of the hearing statements that were submitted. I've no doubt things have moved on since that time, and of course we've had discussions at the policy session and yesterday's design consideration sessions, which may also move things on. So what I'm proposing to do is run through the bullet points and have a discussion this morning, and then what I would say is that I'll be giving both parties some homework to make your final submission, and if there are any comments, then that can be dealt with in closing submissions. So on that basis then, so are there any other procedural matters that we need to discuss?
So there's one. So it occurred to me overnight when thinking about closing submissions that in terms of the Sistra material, the Council having pointed out that the 2017 material and the 2019 material had been produced on the basis of average maximum over the peak period rather than the peak hour. What we did as a matter of urgency yesterday was to produce the proper figures for the 2019 Sistra document. But ruminating on the cross-examination of Mr. Diamond on Tuesday and on and the evidence yesterday, it appears that both parties, Community Council and Perth and Kinross Council, may be seeking to compare the the average maximum with the findings in the transport assessment, and that would be would be an unfair comparison unless you had the equivalent material of the 2017 SISTRA report with the average maxima over the proper period, because I think it's all been agreed that and we can see that there are different figures between the 2017 SISTRA and the 2019 SISTRA reports. So I've asked Mr. Diamond, we haven't got it yet, to be able to prepare so you have a simple 2 lines of average vehicles weighting and average maximum vehicles weighting equivalent to the APP16 document for the 2017 SISTRA, so that when there's a comparison with the LINSIG model, it's done on a proper basis, so that it's done on the data that was fed into the LINSIG model, not data that came in 2019. That is simply a mathematical, that all the data is there in the system material. I'm hoping that may be available before we finish today, but if it's not, and the council would need to check it anyway, I would hope we could pass that on to you. Hopefully I've explained that well enough, but it's to ensure that a fair comparison is made, because as I understand the council's and the community council's case, it is that the LINSIG model significantly underrepresented the, if you like, the average queuing times. And if you're going to compare that, it's proper to compare it with the 2017 SISTRA model, because that's the base information that fed into the LINSIG model rather than the 2019. Although there's not a significant difference, there is some difference between the two. And we should have provided both of those to you on Tuesday or Wednesday, whichever the day was, but that nuance had escaped us at the time.
So if I can just summarise my understanding. So what you're asking is to submit an additional document, let's call it APP17, which would be very similar to APP16 but would refer to the 2017 SISTRA model, and that would be addressing the differences between peak period and peak hour. Have I got that right? Mr. Ellis, any difficulty?
Only to agree with what Mr. Finlay said is we would need the opportunity to check them and also make comment on them.
It would simply be a mathematical situation, and if the council had concerns, I'd invite them to come back to us direct, yes, and then we could agree it. But
Community Council?
We already recognised these difficulties and did the calculations before this meeting, so we have the numbers, but certainly we'll be happy to see the new version.
Okay, well, I will add that to our wash-up session, and we can incorporate the things there. Is there anything else we need to discuss? Right, so we move straight on then to item 2 on the agenda, and the first bullet point. We've obviously discussed this at the policy hearing, so perhaps I can just check my understanding. What I took from what I understand is the appellant's position is that you accepted the policy requirement for a planning obligation for the matters set out by the council for the planning permission in principle, and you saw no legal or policy barrier in arranging for that obligation to be signed and discharged at the matter specified in conditions stage. Have I got that right?
Sorry, yes, that's correct. What I would say is, from the appellant's perspective, the reasons that the council has given for not having a Section 75 at this stage, namely they don't know the number of units on the PPP, I would not regard as insurmountable to putting a Section 75 in place at the moment, because the contributions, whether it's affordable housing or the education or transport contributions, are on a per unit basis. And certainly my experience is it's more common to have a Section 75 put in place at the PPP stage than to leave it to the AMC stage. And there would be a preference, but I wouldn't put it any higher than that, from the appellants for that. But equally, we don't see any legal or policy difficulties with what the council are proposing.
So you, okay. Say a preference. Are you actually going so far as inviting me? Because the mechanism, because it's before me, is that if I feel there's a need for a planning obligation, is that I would issue a notice of intention, and that would be an opportunity then for the parties for a period of time, and then either it's signed, or if there's a dispute, then I will have to reconsider the matter. So, you said it's a preference, but what's your advice? How do you think I should deal with that?
I think, sir, from the appellant's perspective...
To be fair, I did express reservations.
Yes, sir.
And Mr. Finlay, I think, said I needed to get out more.
Yeah, well, I'm not saying I have to say, sir, but my sort of experience is the same as your own in this, that the Section 75 is generally put in place at the PPP stage, rather than left to the AMC stage. On the PPP application, there may be points of detail in the drafting, but I think that the council and the appellants are pretty close on that. So I don't want to overstate it, because we do recognise that the council's approach is one that they've used before. We don't see any legal or policy reason that you should not do that. So it is a preference that we put the Section 75 in place as part of the PPP consent now.
Okay, thank you. Council, any thoughts or comments on that?
For smaller sites like this, in comparison to some of our strategic sites, we have used the conditions that we've recommended in terms of the developer contributions. It hasn't been challenged by any landowner or developer in the past, but failing that, if a Section 75 is required, it can be done that way. We don't have a particular problem with that, but for sites of this size and nature, we have used conditions because we just don't know the figures just yet.
Well, I hear what you say. We'll have a look at the detailed wording of the conditions when we come on to that point in the agenda. Right, if we move on to the next bullet point, and we touched on this at yesterday's hearing session. Let's start with the appellant. Is there any need, do you think, to secure management of common areas by way of a planning obligation for the planning permission in principle?
Certainly, sir, from our perspective, we do feel that there's merit in having such an arrangement formalised with the council, and we would suggest that that could be dealt with by way of a planning condition. The most recent exchanges that we've had with the council have been along the lines that we have sought to draft the terms of the condition to drop into any planning permission.
So you accept that there's an issue about common management, but that it's most appropriately done by way of planning condition. Would that be fair?
Yeah, Chair, I think that's our position.
And for the council?
At this stage, yes, a condition would be fine. I think it would be required to be included in a future Section 75.
I'm not sure I follow you.
If we're doing conditions to cover the obligations at this stage, it would need to be included in the AMSC, which would require Section 75. But if the preference is to move for a Section 75 now, it would need to be included now.
Right. So is the council's position, leaving aside when it's done, is the council's position that it's necessary to make the development acceptable, that there is provision in a planning obligation for management of common areas?
Yes, we would use a planning obligation if the council was adopting and maintaining the ground. So it would be the same if it was through a private factoring.
And my understanding from the appellant side was they were proposing to use a factoring arrangement. So what would the planning obligation achieve that couldn't be achieved by a planning condition?
The planning obligation would detail how much has to be paid by each residential unit in terms of maintenance of the common ground, what areas the common ground are, and that will include a potential future play area as well.
And so my point was, well, why does that need to be? I can understand that, but why does that need to be a planning obligation as opposed to a condition, which would typically say these details to be agreed at a later date?
We would want comfort on the emphasis that it can actually be delivered and controlled, and potential fallback if private factoring failed, and it may be a requirement for the council then to step in.
Okay, appellants want to come back on that?
So I think all of the points that Mr. Callan raises would be captured in the factoring agreement that was required to be submitted and agreed with the council pursuant to the planning condition. I think as Mr. Littlejohn mentioned yesterday, in addition to that, the appellant would be putting in place a deed of conditions for individual residents who would then be bound by the deed of conditions, which is a separate matter, but they'd be bound by the deed of conditions in terms of the factoring arrangements. But so far as agreeing the detail of factoring and enforcing that, I don't think there's anything in what the council was saying that couldn't be dealt with by a planning condition rather than through a planning obligation. The other point I'd make on that is if you are able to deal with it by condition, bearing in mind that factoring can be a sort of a bit of a moving issue and needs updated, it's easier to do that updating with the council direct, where you have an agreement agreed pursuant to a planning condition, than if you have to do it as a planning obligation, because varying a planning obligation takes you through the Section 75A process, which I think would be, in the circumstances, disproportionate and unduly onerous.
Okay, council, persuaded by those points?
Partially. I'm not sure if there was a requirement to do it through Section 75. I think it could be done along with the other planning obligations. I don't think there would be a need to do a Section 75A.
Right, well, there's obviously a difference of opinion there. Are there any other matters that should be included in a planning obligation agreement for the planning permission in principle proposal? Can I ask the Community Council, I think from your hearing statement, you had a suggestion that road improvements to Lochie Bray may be a requirement. Is that still your position?
Yes, indeed. As we have said, sir, the use of Lochie Bray is the main means of coming from the site and coming to the site into the road network. It's narrow. It's, as you'll have seen, it presents safety issues. The Community Council is persistently having this brought to our attention of safety issues on Lochie Bray. The background of this is going back to something like 2007 and 8. I don't have the details to hand, but with a previous planning application for this site, which failed to get planning permission, there was actually a specification to allocate money to improve, essentially widening Lochie Bray. The council actually owns a 5-metre strip of land along the side of Lochie Bray. And so there are opportunities to actually improve the safety aspects of this road as have been identified. Essentially, the main item which is preventing this, of course, is availability of money and prioritising resources to resolve the problem. So that's what we're alluding to.
Thank you. I'll do it this way. For the council, do you see any need to make the development acceptable along the lines suggested by the Community Council?
Sort of kind of fully understand where the Community Council are coming from, but more from the legal perspective. From the Council's view is that because it's a pre-existing problem, it is difficult to put that at the door of this particular developer and ask them to pay for all those costs. You're getting into it not being reasonable, and of course it hasn't been defined exactly what all those improvements would be. We don't know what the cost would be, but also the Council's position, of course, on the traffic impact is there's going to be a significant improvement with CTLR coming through. So taking all that into account, whilst appreciating where the Community Council is coming from, I think for these particular applications it would be going too far.
Pelland, any thoughts or comments?
So there's the Council in the Reports Committee identified a transport contribution which, in respect to the PPP, the appellants have confirmed that they're willing to pay. Beyond that, there's been no justification for a specific intervention. So we'd agree with the Council on this point.
Committee Council want to come back on the points just been made?
Just one comment, I think, on the Perth Council's statement is that I don't think this relates to the Crosstail Link Road in terms of potential solution.
Okay, any other points we need to discuss about planning obligations for the planning permission in principle?
Just one thing in relation to the open space management. I think the core path area would need to be included because that's within the landowner's ownership, clearly.
Okay, are we done?
Sir, just in relation to the core path, the most sort of recent suggestion by the appellants has been to include reference to maintenance and management of the core paths together with the broader factoring and management arrangements across the site, and we feel confident that that can be dealt with by way of a condition.
Okay, I'll try again. Are we done now? Are we done now? Right. Let's move on to item 3, and this is the detailed planning permission. And if I can quickly take the first 4 bullet points. My understanding from the appellant is that whilst you accept that a proposal would normally be liable for those contributions, in the context of a detailed planning permission for change of use of a listed building, also in the context of a proposal that needed to be seen holistically so that the conversions could only take place if the development in the grounds was also allowed, that any planning obligation would make the scheme commercially unrealistic, and therefore I should not place a planning obligation on it. Have I got that right?
Yes, so that's correct. Sir, just by way of an update, and following discussions with the council, the appellant's primary position, as you know, is that the viability position is self-evident and was a feature of discussions between the appellants and the council during the application process. That said, we have said to the council that the appellants would be willing and able to do a viability assessment prior to commencement of development or the redevelopment of the listed buildings to demonstrate the viability position, that could be dealt with through a Section 75 agreement, so that you would have the obligations, but these would be subject to the viability assessment being done first, and then the obligations, the developer contributions, would then be determined by the output of that viability assessment, whatever came out of that process.
Okay. I think I need to think about that a bit. So, your primary position is how I just explained it. That's
yes.
That's what you're. However, I think what you're saying is if I had any concerns about the viability issue, a way that could be adopted is that I issue a notice of intention setting out the normal requirements,
Yes,
with an understanding that there would be an opportunity for you to make your own viability assessment. So when I give my standard 3 months for you to discuss these things, you would have the opportunity to persuade the council that it's not viable, and you would then come back to me. Both parties would come back to me and say it's okay, we don't need to do this. Yeah, perhaps I got that wrong.
So yes, in essence, that I think from the appellant's perspective, that would work. It would be on the basis that if agreement on the viability couldn't be reached with the council, that you would be there to make the final determination on that point.
That's your secondary position. That's not, you're not advocating that.
No, sir. It is very much secondary to our principal position is as you set out.
Right. Council, any thoughts or comments on what you've just heard?
In terms of the viability of the listed building, if we were remaining as the determining authority, we would require it to be upfront before we would make a decision. So the timing of when the viability assessment is done, I think now rests with yourself. But if it was the council, we would require it to be done before we could issue a decision, because we'd be in a position where we'd know what the viability was, what level of a potential discount would be in terms of the developer contributions, and that would be agreed before we could issue a decision.
And do you have any particular comments on the suggestion that I issue a notice of intention and it's left between you two to argue out the viability?
That's kind of putting the decision around, perhaps, which legally is the opposite of what would normally be the case, and simply that it would normally be assessed within the application before issuing a decision. I know really I think my decision really appeared to be your decision at this stage. If you wish to, of course it's within your right to ask for a viability statement yourself, which parties you comment on.
I think you have a counter to the secondary position. So your preference is that instead of using a notice of intention to flush out the arguments about viability, I simply issue a further procedures notice and ask for that information up front.
And of course, as a primary position is that it's not been justified to us to remove the contributions. But it is very much the secondary position would be as you've stated, yes.
So your primary position is you reject any suggestion that it's self-evident.
Yes, that would be correct, yes.
Pallant, any thoughts or comments on what you've just heard?
Yes, so that obviously it is another way of doing it, but your suggested procedure is far swifter and more cost effective, and we have to bear in mind the deteriorating condition of the listed building. The longer one waits, the more it will cost to refurbish, the more likelihood of significant damage, and so there's no good reason not to follow the route that you suggested, because it has the dual advantage of having a short period and a potential for swift adjudication if there is disagreement. I understand the council's position, but I also understand the reality that they have a realistic sense of the condition of the hospital. So that, again, one would hope that you wouldn't be called upon to adjudicate anything. But we are in a position to provide a viability assessment in very short order.
Okay, anything else we need to say about affordable housing, education, transport infrastructure and viability for the detailed application? Are we done? If we just move on to chapel use and management, and we've touched on this yesterday and just now in the planning permission in principle. For the council, bearing on what you've just said, for the planning permission in principle application, is there a need, in your view, for a planning obligation for this proposal?
From discussions with the appellant, we've looked at a couple of options. One where the maintenance of the chapel falls within the factoring arrangement, and B, that there is as part of that proposed condition that any change of use will be subject to a further application, because its use could continue as is without any requirement for a change, but there will be a requirement for maintenance and upkeep.
Okay, but my understanding is that the red line for the planning permission, the detailed planning permission, it also includes open areas which aren't in the planning permission in principle one. So why would you treat the two differently?
Can you repeat that again, please?
My understanding is that the red line for the detailed application also includes areas of open space, separate to the areas shown in the planning permission in principle application. So if it's the council's position that for maintenance arrangements for open space in the planning permission in principle, I might need a flip chart to explain this. If it's the council's position that I need a planning obligation for open space in that application, why would you not have an obligation for open space in the detailed application?
From what you're saying, it would suggest to be contradictory. So a factoring arrangement or management plan would be required for both the IPM and the FLM, because there is open ground within the red line, and this open ground also includes a chapel, which there is no proposed change of use, but does require ongoing maintenance because for a number of reasons it is listed and it needs to be maintained.
Appellant, any thoughts or comments on that?
So just a point of information, really. The refurb change of use development effectively could block of flats and has communal areas within it which would be subject to, as I said earlier, either conditions or a management arrangement, as you would have between residents of a block of flats, and I think the chapel would be included within that arrangement. That's certainly the appellant's intention. It's slightly different, perhaps, to the new build element. It's like it's a residential development of individual houses.
Right. So do I take it your answer would be the same as for the planning permission in principle, that there is no need for a planning obligation to make the scheme acceptable in terms of the maintenance arrangements?
Yes, so that's correct. It dealt with that condition.
But if I was persuaded by the arguments of the council that an obligation is necessary for open space, then I'd have to treat both applications the same, would I not?
For consistency, I suspect you probably would want to do that. Our view is that these are matters that can be dealt with by condition rather than obligation, and therefore in terms of the circulars on conditions and obligations, conditions should be used in reference to obligations where that can be done. But if you felt that for one of the applications you needed a planning obligation for that particular issue, then it does follow that the same approach should apply to the other application.
Yeah, I mean the difference is that we have two applications and they cover different bits of land. So if that was important, you'd have to capture both.
Yes, I think that's accepted.
Okay, any other potential matters for planning obligations for the detailed application? Are we done? Nothing else? Okay. Right, can we turn now to item 4, and this is recommended conditions in relation to the planning permission in principle. So I'm just going to run through these bullet points. It may well be that in the light of your discussions that we can dispose of these things very, very quickly, and I can just await for your final version. But let's see how we get on. So the first bullet point was general principles, and what I meant by that is that at similar sessions as to this on other cases, there does seem to be a difference of opinion as to whether the purpose of the planning permission in principle is to specify in detail the constraints within which the matters, the application for matters specified in conditions, I want to say reserved matters, because it's less of a mouthful, of which the reserved matters work within, or whether you instead rely on just consideration of details at the next stage. And we discussed that yesterday, and my understanding was the appellant's clear preference was to rely on the approval of details. Have I got that right?
Sir, that is our position, yes.
I think the council was a little bit more mix and match depending on the circumstances.
By and large, we would agree with that. There is a little bit of mixing and matching. There is a request for further information at reserve matter stage. There are some proposed conditions which kind of provide a bit more clarity in terms of when the development in whatever format is delivered, but it should be clear that it's there and in place.
The other general principle, and I suspect this is a style choice, is that when further details are asked for, sometimes it's just a general request for a scheme covering a particular area. Other times, and certainly in the council's version, the details of the details are specified in some detail, A to M, for example. Does the appellant have any view on that kind of style choice?
I think, sir, from the appellant's perspective, we think there is a degree of duplication in the council's draft conditions, which we've spoken with them about. But and I'd agree that there's quite a significant amount of detail within the detail. That said, these are not things that give the appellant, the details are not things that give the appellant any particular concern. So they are things that they would reasonably expect to see once they get to that stage. It might be moot whether you need to put them in conditions now, but if you felt that that was appropriate, the appellants wouldn't have a particular concern with that.
If I can just ask the council, it's occasionally put to me that there's no need to have a long list of the requirements if you're asking for more details, because if they're reasonable requirements, you would merely not discharge the proposal. And the downside to having a long list is if it implies it's exhaustive, and if something's missing, then that can give a difficulty. Do you have any comments on that?
All I would say, it is a standard format of conditions that we use for in-principle sites. You do have a list. It is quite a long list, I would agree. And the follow-on in terms of the further details, it's trying to provide clarification of what's required within each subject area. So if there's a construction environment management plan, it's not just to simply state you submit a construction environment management plan, it's to provide details of what needs to be submitted. So when it comes to the reserve matters application, that we're now still not missing information and causing a delay in that application process.
Okay. Can we now move on to the next bullet point, time limits? If I can start with the council, what's the reasoning for the 6 years? Is that entirely related to the timing of the Cross-Taylor Link Road?
Partially, we are proposing a direction. Obviously, under the Planning Act, there's 3 years. We're proposing a direction because, one, because of the Cross-Taylor Link Road, and that may have an impact on your decision in terms of the timing of an application, but also that the application may come forward in phases, and what we were trying to reduce the risk of is somebody trying to submit a reserve matters application out with the 3 years. We have experienced it before, and we do use directions where we feel that there's going to be a longer construction period.
Okay, appellants, any thoughts or comments?
So my understanding is that a period of 6 years is agreed with the council in terms of implementation of the planning permission principle. Our understanding is that that is related to the delivery of the refurbishment of the listed building development. It's not linked to CTLR. There's in the draft conditions that have been circulating between ourselves and the council, there is a condition dealing with this issue and picking up with the 6 years.
Do you agree that there is a reasonable requirement to not use the standard period?
Yes, sir, we do.
Okay. Anything else we need to talk about on time limits? If we can now move on to phasing restrictions. And I don't want to rerun the debates that we've had. So let's just focus on the wording of the conditions. But for the council, my understanding of the totality of the evidence that I heard is that your primary position is that no development should take place until this cross-Tay link road becomes a committed development in your definition of committed. Is that correct?
Are you referring to just the in-principle application?
We're looking at the in-principle application, but it clearly has implications for the detailed one as well.
It is true for the in-principle application. There's a bit of a difference with in terms of the detailed development in terms of the building. And what we were looking at there was for a phased delivery.
Okay, we'll come on to that in item 5. The appellants, any thoughts or comments on what you've just heard?
Sir, if I can explain the phasing condition proposal put forward by the appellants in comparison to the council. The appellant's phasing condition is heritage driven, if I can put it that way. The purpose of which is to ensure or to give comfort to you and to the council that a significant proportion of the refurb development would have to take place before the new build could be released. It's not something the council has actively sought in a heritage context, but it's something that the appellants thought probably want to see. So that's the driver for that condition on the part of the appellants. By way of happy coincidence, perhaps, and you heard, I think, yesterday about build-out rates and 15 units per year, 30 units obviously over 2 years in the refurb. The practical effect of that is that the phasing condition that the appellants are proposing, the timing of that will in all likelihood coincide with the CTLR being a committed project. That's not, I stress, that's not a deliberate attempt, but the appellants do recognise that that's probably in reality the practical consequence.
Well, you've anticipated my sort of secondary bullet point there, but I mean, in terms of the phasing for Cross-Tay Link Road, it's your position that there's absolutely no need for that.
Yes, sir, that's correct. Our position is that the transport evidence doesn't justify a condition restricting development pending CTLR being a committed project, and the council's attempts at de facto embargo are not properly made out. From the appellant's perspective, again looking at the practicalities of this, the CTLR, the delivery of CTLR as a committed project isn't in the appellant's control. It's not something over which they have control or indeed any real direct influence. And making delivery of this development contingent on the CTOR would effectively prevent the development going ahead at all. Sorry, just to expand on that point, it's because the appellant, to embark upon and incur the costs of the refurb development, needs the comfort of knowing that, provided he does what's required of him, the new build development will then be unlocked, if you like, and he can bring that forward, and that there's no impediment to that other than things that are in his control, either completely or over which he's direct influence, that, such as the discharge of the conditions and the building out of 30 plus units within the refurb. These are all things of which the appellant can take a reasonable view, but the CTLR and the timing of that as a committee project is something that's completely out of his control or sphere of influence.
Okay. Well, whilst you've got the mic, when it comes to your suggested condition for ensuring the implementation of the building conversions, why is the 2023 date as an alternative?
In essence, sir, this was put forward because it reflects the reality of the situation. We're June 2019 now. Work on site, development work on site, as opposed to maintenance work on site in terms of the redevelopment is probably 12 months away, and so 2 years to build out the units. The appellants were proposing that to give comfort or certainty, rather, as to timing issues.
I can see the planning rationale for saying that a certain proportion of the conversion has to be undertaken before the new build in the ground is in the grounds are occupied. But why stop that arrangement at 2023? If there's a heritage argument, why wouldn't it be absolute?
So I don't think it would, because it's the later of. So it's the later of completion of 30 units or January 2023. So if we got to January 2023 and 30 units hadn't been completed, the obligation doesn't disappear. It's the 30 units that takes precedence. So it's the later of the two.
What is the function of the 2023 then?
It is, well, in essence, it's to provide certainty to you as to the scale of development that would be coming forward in that development window. And as I said, the appellant is comfortable committing to that date because it reflects the reality of the situation based on his previous experience of similar developments elsewhere.
Okay. Thank you for that. Council, any thoughts or comments on that?
Clearly the decision rests with you, sir, in terms of whether you agree that there's a requirement for a phasing or not. If there is to be a phasing, I would agree that the date suggested by the appellant is more closely aligned with what the council are now seeing after the Crossdale Link Road went to full council last week, and we're looking at potential dates of contracts let in autumn 2021 and committed in early 2022. the reason for our proposed condition is that it's consistent with other consents that we have issued in terms of Schoon North, which is obviously a larger development, but also for just further up the road, Perth Airport for 50 units, and it's the exact same wording of condition that no new build until the CTLR is a committed project, and a definition of that committed project is included in the proposed condition. And if we were to depart from that standard condition that we have now been using, it may leave us open to challenge by other developers on consented sites.
On the specific point of a condition for heritage reasons to ensure the implementation of the building conversions first, do you take any issue with that?
We certainly wouldn't stand in the way of the conversion of the listed building coming forward for us. Indeed, I think that's something we've discussed a long time with the appellant from day one. That is something that would be our preference, and that may well be the case when the LDP2 comes out as well.
Okay. Anything else we need to talk about phasing conditions?
Sorry, I could just pick up on a couple of points Council made. The first point is to stress that an open-ended CTOR condition would not enable this development to go ahead at all, because it doesn't have the certainty that the developer requires. And that's what the Council's draft condition proposes. So there would need to be a fixed date in any condition. On the issue of precedent, 2 points on that. The first is that the justification in this case is the condition of the listed building and the purpose and objective of this development to secure the long-term future of that listed building. And I would simply note that my understanding is that the Council did not impose any CTOR condition on the Ganaki development.
Council want to come back on those points, and then we can move on.
I think there's kind of a little bit of a hierarchy here in the sense, of course, you've got your decision on the traffic impact, first of all, and our primary position on committed CTLR. If you only look at it as heritage impact, then of course, we would have no objection to, I don't even have any objection to the condition you propose. In terms of the Ganaki development, simply say the Ganaki development is quite a different development.
Okay, thank you. Are we done on phasing? Can we move on to scope of permission and design constraints? Let's see if we can do this in quick order. My understanding from our discussions yesterday was that and from your hearing statements, there's an agreement that it's an indicative layout. There's no commitment to 70 dwellings, and that there's no need in the planning permission in principle to actually define spatially developable areas or exclusions, with the possible exception of no development beyond the southern wall. Is that a fair summary?
I think so. That is a fair summary of the situation.
council?
I would add in the entrance in terms of the parameters of the protecting that view.
Have you any? I think. Have you any thoughts on how a condition could do that?
I think what we would be looking for is to provide essentially a buffer, so agreement of a buffer to maintain and protect the view of the front elevation of the A-listed former hospital building.
And in your version of the conditions you've been working on, have you provided with a suggested wording for that?
Not as yet.
I think I would strongly recommend you do, rather than me to try and guess what you think you mean. Appellants, any thoughts or comments?
Yes, sir. I was just going to add that in the most recent exchange with the council, we have sought to suggest some wording in that respect, effectively to detail the extent of housing development within the western extent of Zone B within the first approval of matters specified in condition application, and with additional clarity that, notwithstanding any details shown in the indicative plan, that the consent would not authorise any development to the south of the boundary wall to the north of the Millennium Park. So that's a draft condition that's just recently been added.
I look forward to reading that with interest. I think we've done developer contributions. We don't need to discuss that for the planning permission in principle. So the next bullet point, is there anything we need to cover in terms of demolition of the buildings in the grounds for the planning permission in principle? For the council?
Certainly, it's our understanding in the in-principle application that there is the former industrial therapy building, but that is not listed. It's very much a modern building. The detailed application is where all the proposed demolitions of listed buildings are included.
Doesn't the red line for the planning permission in principle include the Gilchrest building?
It was my understanding that the Gilgal building is included in the detailed application in terms of the change of use, alterations and demolition.
So perhaps
Helen, can you help us with that?
Yeah, sorry, I was just going to clarify that my understanding is that the planning permission principle does include, or the red line does include, the former Gilgal building. The entirety of the site, however, is covered by an application for listed building consent, the application which we previously referred to as being taken forward by the council at this stage. So within that application, which, as I say, includes both the detailed application boundary and the application for PPP boundary, there's various different demolitions detailed within that.
So in short, I'm taking from both parties that in terms of the planning permission in principle, there's no need for any conditions controlling demolition, because any that weren't kind of fairly modern buildings would be addressed through the listed building consent. Is that right?
That's correct.
Right. If if we can then just go through to the next bullet point, and what I tried to do there, because the versions that you gave me in your hearing statements were of different styles and sometimes different matters, certainly different orders. So I tried to pick out general topics, and I'm just going to very quickly run through them and just check that you're all comfortable that they are necessary and relevant, and perhaps your more recent work will make that a particularly easy exercise. So the first one, archaeology. Is there agreement that archaeology is needed? A nod will do if we can shoot through these things. Archaeology is needed. Something on biodiversity. Yeah. Construction management, including dust control, construction traffic and working times, are all those necessary? Yeah. Various design and layout, including levels, building heights, fencing, materials, etc., etc., all those necessary? I think I saw in the council's version various references to drainage. I thought that there had been work in association with the environmental impact assessment, which meant that effectively the existing system was going to be utilised. So I'm just wondering whether those drainage conditions are strictly necessary and will be picked up in practice by whatever Scottish Water required. But any thoughts on that from the appellants?
I think certainly from my perspective there's probably still merit in including the references in there. Certainly in terms of the discussions to date in relation to drainage in particular, there's very much an arrangement in place for the detailed planning permission. The application for planning permission in principle is sort of based on a layout which is agreed in principle, but other matters need to be detailed, I think, within the matter specified in condition.
So you're satisfied that drainage conditions are necessary? For the council?
We would agree. It's the listed building would obviously, it's already connected up to the system. The in principle application through detailed design, there may be a requirement for a suds pond. We don't know at this stage.
Really a requirement for suds pond?
Or some form of attenuation. Well, we would expect that it would go into the existing infrastructure. But
next one, I think I saw a condition about environmental sustainability. I thought I heard the council tell me to turn a blind eye, but is that really necessary?
it's just to provide clarity on the future house types, what their environmental credibility actually is.
Appellant, is this sort of condition necessary?
So certainly our position would be that we could accept a condition along those lines for the detail, obviously, to come forward at a later stage.
Green travel plan, including core paths and charging points, etc. Is all that necessary? Yeah, yeah. Land contamination? Yes. Yeah. Landscaping and trees, including long-term maintenance? Yeah. Noise? Waste management? Are there any other relevant? So I take it when I see your versions, all these things will be captured, and that you've had these discussions. Are there any other relevant conditions that we need to discuss for the planning permission in principle? Okay. Let's turn to item 5. On the general principle one, if I can start with the appellant, because there are two applications with two red lines, which, if there are matters which are common, for example, construction management details, they're not. I take it they've got to be included on both. Would that be correct? And would the council accept that? Just another sort of general point. Let's start with the council. I've seen such conditions regularly, but on your version, there's one which says the development must be in accordance with the approved plans. Would not any proposal have to be developed in accordance with the approved plans, and therefore that condition isn't strictly necessary?
It works both ways. Yes, if there are approved plans, they would have to be, you would expect it to be delivered, but it is a standard condition that the council have used.
Helen, any thoughts on that?
Thanks, sir. I would agree with you in terms of perhaps it's a statement of the obvious more than anything else. This is perhaps an example of what happens when conditions that backwards and forwards between an applicant and council are then subject to detailed scrutiny. But having said all that, I don't think we have a particular concern with it being included.
Okay, if we can move on to the next bullet point. I saw in the council's version, well, both versions actually, a range of conditions about further details and restrictions within the conversion. Are those necessary? Would all that not be controlled by the listed building consent and the listed building legislation?
So the phrase that's just been used as belt and braces. At one level, you're absolutely right that these are matters that would be caught in the LBC, and so the appellant recognises that they're going to apply to them anyway. If the council are looking for them to be included on the detailed consent, that they're not. It's something they're already going to have to do.
Council, any thoughts on that?
Would agree with that. I think it was very much a belt and braces approach. The listed building consent decision notice would reflect most, if not all, of those cultural heritage conditions.
Do we need to discuss phasing in relation to the detailed application, or have we done that to death?
I would be tempted to say, so I think we've probably covered that or done it to death. Just before we leave the detailed conditions regarding the listed building, just one point just occurred to me. The listed building application has been pending for some time and is on the cusp, we think. We've provided the council with the extra information that was required. If the council are able to give an indication of when they expect to be able to make a decision on that application, it may be that you will have sight of those conditions before making a final determination on these appeals. So if the council are able to give an indication of when they expect that to happen, I think that might help clarify the need for these conditions.
Council, can you assist?
Yep. We got the further information that has gone out to, in terms of the details, especially in relation to the internal details and the further details on the conservation plan. That has gone to Historic Environment Scotland and our conservation planner. I would expect to have their responses back within the next couple of weeks. I have a report drafted. It would need to be amended, but we are talking a few weeks.
I'll add this to my list. Could we make an agreement that if you do issue the listed building consent, you'll let me know and send those details? I think that would be helpful, because I don't have anything before me as it stands at the moment. Would that be a sensible way forward?
Yes, sir. Thank you to the council for the clarification.
So we're comfortable we've sorted out phasing. Based on our previous answers, we're comfortable we've sorted out demolition. Many of the details were very similar to the two things. I've got your comments on that. Is there anything we need to talk about in terms of the further details? Or will that all have been sorted out in the wash when I see your versions? I did observe that the council's waste conditions did seem to be exceptionally detailed in terms of setting out size of bins. I take it that you've had a chat about this.
It's exceptionally detailed feedback we get from our waste services department in terms of clarifying the requirement of bins. We have on occasion for other developments where it hasn't been clarified and a developer's gone and put in bins that the council aren't of the right dimensions and difficulty in picking them up as well. What we were looking for here would be a centralised location and try to minimise its visual impact as well, but it is just to clarify the required size and amount of bins.
Okay, are there any other relevant conditions we need to discuss under the detailed proposal? Are we done? Any other relevant matters that we need to discuss? I've been galloping through that. I don't want to go without just asking, have the Community Council had the opportunity to say all the things they wanted to say on these things?
Thank you, sir. Yes, I think the only points that we would raise where we perhaps strongly disagree, it relates, as you might imagine, to the discussion with regard to the conditions surrounding the Crosstay Link Road. As you know, our position is that we don't believe there's a clear statement of the traffic congestion situation in front of you. Against that background, we think that the timeline assumptions about the Crosstail Link Road need to be questioned. With all due respect to Perth and Kinross Council, this certainly since 2013 and beyond has been a moving feast, and we don't believe there is sufficient confidence in their current estimates with regard to its commitment and completion time. We also have our concerns about the effectiveness of the Crosstail Link Road. We think there are too many assumptions being made there about the return it will give to the traffic. And on those two grounds, we think that both the appellant and the local authority are being unduly optimistic.
Okay, I've noted that. Council, any comments on that?
Nothing further to add.
Appellants? Okay, on that basis then, that's the end of the obligations and conditions hearing session. I'm not going to hold a break. I'm sure we can just bash on and we'll be finished shortly. But can I just round up all the matters that we've discussed? So what I'm expecting to happen is that within a week, having reflected on this discussion, I will have one version from the appellants and one version from the council of their suggested heads of terms and conditions. And if there's anything outstanding, that can be picked up in the closing submissions. I will get my case officer to speak to the local development plan 2 case officer, and we will draft a procedures notice which will be cunningly coordinated with the publication of the examination report, and I would normally give 14 days for the parties to comment on that. Is that reasonable? Is that a reasonable timescale?
So I don't know whether parties' comments could be incorporated in their closing submissions to short-circuit the procedures that would be needed afterwards. I've had some discussion with Mr. Elliott, but that would be my suggestion, so that we want to go straight to closing submissions 14 days or thereafter. I know there are holiday commitments rather than having an additional round, but whichever you would find most helpful.
I'm all for quickening up the pinging of bits of paper between parties. The problem with relying everything on closing submissions is if there's any conclusions on that which the Community Council and the Council take issue of from yours, they don't get to see your closing submissions until the end. So let's see if there's agreement. So the Council, any thoughts on Mr. Finley's suggestion that rather than a two-stage approach, we try and do everything by closing submission?
I don't think there were any fundamental objection, as Mr. Finlay said. It's much more a practical issue in terms of holiday times, in terms of the scales. If you order within 14 days, I myself have 2 weeks holiday coming up mid-July, and that might be a problem if the time scale of 9th of July is about met. I'm off the 15th to the 26th. So it's the practical implications more that's the difficulty.
Right, so is that a yes or a no?
No particular objection to what Mr. Kennedy says. It's just hopefully then, if you give us 14 days, that neither of us are off.
For the Community Council?
I think we too have issues with availability of people over the next period, again through holiday commitments. So I think we're in a similar situation to the local authority.
Right. Well, I'll tell you the two alternatives: timescale, and then perhaps the issue is about timescale rather than the principle. I'll tell you what I was assuming would happen, and then let's see how that goes. So, option A, this is Dan Jackman's timetable, would be conditions in by the 4th of July. If we assume, and it might be, let's assume that LDB2 is published by the 9th. If I gave you 14 days each, that would be comments by the 23rd of July. And then if we did the conventional round of closing submissions, which normally we would give a week each, so that would be Community Council by the 30th of July, the Council by the 6th of August, with the appellant having the final say on the 13th of August. So that's what I had assumed. I think what Mr. Finlay would be proposing would be accelerating that, so the community councils would be in on the 16th of July, council 23rd, and the appellant the 30th. Is that what you'd be suggesting?
I am cognizant of holiday time, so if that's my starter for 10, if we can put it that way, but I know I'm aware that others have holiday time, so I'll back that over to the council.
Okay, so of those two options, which does the appellant favour?
Well, the accelerated option, but without being wedded to those particular dates.
For the council?
Unfortunately, I couldn't do either just because of the timing of my holidays. Yes, in terms of your first option, I would only have 3 days and Mr. Callan's off, so in terms of us discussing it wouldn't be practical. In terms of your second option, as I said, there are no objection to, well, you used the word accelerating, but the difficulty then is I am off from actually on the 12th right through, and I don't come back till the 29th of July. So it's unfortunately it's just a bad time of year. I'll blame the kids, we're stuck with school holidays.
Well, yes and no. You could start writing your closing submissions now. The other. So make me an offer then. If those two aren't, make me an offer.
Well, without complicating it too much, I'm on both committee and licensing board next week, but I will be starting things as quickly as I can. Without wanting to make it particularly later, if we shifted up in your first option, you were talking about 30th of July for closing subs, 6th of August and 13th of August. We shifted those up 1 week, but as the only dates. If you like, I'll rephrase that. If you did only closing submissions, and I think it would be Community Council by the 6th of August, if that is available to them. Council by the 13th of August, which would put the appellant by the 20th of August.
But we wouldn't have any separate comments on LDB2, that would just be incorporated in...
Of course, a master for yourself, but I think we could do it.
You say that, but is the council comfortable with that arrangement? Because you don't get to see his comments.
I appreciate that, but yes, we'll go with that.
Right, okay. And the Community Council, what about that third option? Does that suit your timing?
That suits us better than either of the first two.
Okay, Mr. Finlay? Right. So to recap then, if I can get the final conditions from the appellant and council by the 4th of July, we will alert, which is effectively what we're doing, alert people when the examination report is available. But we're now anticipating closing submissions from the Community Council on the 6th of August, Perth and Kinross on the 13th of August, and the appellant on the 20th of August. Is that agreed? Yep. Okay. Any other procedural points we need to discuss? Is everyone clear what we have to do?
The only procedural point is APP-17. We could give you a hard copy to take away now and forward a electronic copy in due course, or we could simply forward an electronic copy to you. We don't have the hard copy printed off now. That may take 5 to 10 minutes. But
strangely, I would like to take a hard copy if that was available. I've got to help Mr. Murray pack up, so 10 minutes would be fine. And I take it that could be circulated to the other parties. And again, it means that if there are any points, they have to be addressed in closing submissions.
Certainly, I think it would be helpful if you set us all a timetable. I was going to suggest the 4th of July to try and agree a final version or explain why it couldn't be agreed, because then it would provide certainty for the Council and the Community Council on their closing submissions. Would be the 2017 Sistra model with the appropriate peak hour rather than peak period average maximum queue length and average queue length.
Right, so I'll leave it to the parties to liaise. And yes, I would be, if there's a problem, I'll expect to hear it fairly quickly, if that can focus minds.
I've just been advised that Mr. Deems is on holiday for the next 2 weeks, but hopefully there's a subordinate who will be hopefully closing. But we'll do our best on that.
I'd like to think that the council has more than one person who can look at these things. Okay, are we done?
Confirm, I think that, sorry, my apologies, Mr. Welton reminds me, we had alluded to the issue of expenses, and we've formally raised that before. I've formally raised that now, and you may expect to receive some submissions in closing submissions on that. The council may wish to, I don't know whether you wish to deal with that now by way of timetable for a response to that,
you can either make them separately, and the council will be given. We would typically give 14 days to respond, or you can put them at the end of the closing submissions, incorporate it with your closing submissions, and again we would give the council 14 days to respond to that.
Obviously, these things have to be considered once we've been able to reflect on the inquiry, but we would currently propose to submit them at the same time as our closing submissions, because it means one gets a proper overview of both.
Expenses is a separate decision that I would have to make. Right. Are we done? Does everyone know what they have to do? Okay, on that basis then, I will close the examination. I would like to thank everyone for their cooperation. We managed to keep well on timetable, and that was only because of everybody's conduct. So thank you very much. I hope you have a safe journey home, and I await all the new information and closing submissions with interest. Thank you very much.